Ребят, я немножко опаздываю. Сегодня встреча важная с юристом Билгай Акил. Так, ну я уже в офисе. Да, это Hello.
Hello, welcome.
Okay. Where is Билгай?
No, it's there.
Oh, okay. Thanks.
You're welcome.
Так, идемте. Hello. Sorry, you Билгай?
No, she's inside.
Ага, she's waiting.
Yes, she's waiting.
В двух словах, это юрист Билгай Акил. У нас сегодня встреча с ней и с директором Дом.Инфо Светланой, той самой, с которой мы уже общались. Она будет задавать вопросы, которые интересуют каждого, юридические моменты. И нам предложили поприсутствовать. Поэтому... О, sorry.
Hello.
Sorry.
Здравствуйте, Константин, заходите.
Спасибо большое. Спасибо.
Мы вас уже заждались.
Okay, Bilgay. First of all, let's talk a little bit about the procedure of purchasing a resale property. Is there any major difference for a purchaser when he or she is buying a resale property as compared to a new property?
There's no difference when you're purchasing property. The process is the same. The only difference is the purchaser will sign two contracts. One is contract of sale, which is signed between the vendor and the new purchaser, and also an assignment contract signed between the former, or we can say contractor owner, and the new buyer. What they have to take into account is that all debts, the full purchase price, is all fully paid to the vendor. Also, you should ensure you review a cancellation agreement between the former purchaser and the vendor.
You mentioned that there will be two contracts of sale. One is contract of sale and the other one is the
That's
assignment
correct.
contract. Which one of them shall we register at the land registry, or do we need to register both of them?
The contract of sale is the essence of the contract of sale.
And it's still, the tax is still the same. We pay 0.5% for the registration of the contract.
That's
no
correct.
changes.
Your contract of sale is the contract which you will pay the 0.5, the stamp duty, and your transfer charges, and also your VAT.
And does it make any difference for a new buyer if the current owner of the property holds an individual title deed?
No, it does not make any difference if it's an individual title deed or shared title deed.
So the procedure is still
It's
the same,
yeah.
proposed.
Yeah, that's correct.
What about the VAT issue? Because normally when we see some listings on the internet, it says it's a resale property, VAT is paid. Is it really so, or there might be some cases when you have to pay VAT for the second time? Could you please elaborate on this a little bit more?
VAT issue is controversial. VAT is 5% here, and when you're buying from a company, the 5% is payable. But this all depends if the former purchaser paid for his VAT previously. So if the contractual owner is selling the property over a higher price than the original purchase price, then there will be a VAT difference. So if the former purchaser bought it for 50,000 and he is selling it for 60,000, then the difference is payable.
Okay, Bilgay, so as far as I understood, even if VAT is paid for resale property, but the title deed is still in the name of the construction company, then there might be a difference in VAT if we resell this property.
If you resale and there's a difference, payment difference, if you're selling it for a higher price, then the VAT is payable, but only as a difference.
Is there any way to avoid paying this VAT difference? Can we state the same amount in the new contract of sale as it was mentioned in the previous contract, and put the amount that we're actually buying it for in the assignment contract? And in that case, will we have to pay the...
No, don't mix up the assignment and those are totally different. Because the VAT issue is regarding the company, and it's regarding the company accountants and the tax offices. So this is a very accounting issue. So it depends on the company.
I see.
So if the former purchaser has not paid at all, then the VAT is payable. But this could be agreed between the parties, or the former purchaser can include this amount and sell it in that direction.
And in what stage can we find out about this VAT issue? For example, I want to buy a resale property and the owner of this property says, I've already paid VAT, you don't need to pay it.
No,
what do I do?
these aspects from the beginning, it has to be negotiated, and all terms and conditions needs to be put in writing in your contract of sale.
But if the owner is rushing me, he says there are 5 other potential buyers, and if you don't pay the deposit now, the property might go to another purchaser, and I want to pay the deposit. And how can I find out all this information about VAT soon enough for me not to lose this property?
You should take your time.
So we should not be in a hurry.
You shouldn't rush. You should consult with your legal advisor, and your legal advisor will contact the company and take the route from there, so you have no surprises later on.
So let's say I chose the property, I'm happy with the property, I want to proceed. What do I do next? Do I pay the deposit to the owner directly? Do I pay the deposit to the legal consultant? What is the general procedure, and when do I need to pay the full amount of money?
We do not advise to pay the contractual owner directly or the company. We're talking about resales, right?
Yes, yes.
So either to pay the deposit to an independent estate agent or the lawyer is the most safest route.
And do you advise to do some search at the land
Of course,
registry?
of
And
course.
what does this search show us exactly?
So when you decide to buy a property, we ask for the title deeds, and we conduct search at the relevant land registry offices. We search whether the title deed owners are the true title deed owners, whether the contractual owner has registered the contract. We check what type of lands there is, and if there is any impediments, mortgages. So once it's regarded secure, then we go ahead with the completion. And when we say completion, is to draft the contract of sale and stamp it and register at the land registry offices.
And what if you conducted the search and there are impediments on the property? What are my rights as a purchaser in this case? Can I get my money back if I paid the deposit already?
Usually a deposit is non-refundable, but in the event that there's any impediment on the property, then your deposit is refundable. And you can claim back your deposit.
Okay, so let's say we conducted the search and everything seems fine, and there is an individual title deed, there is no VAT to pay. Are there any other issues that we should be aware of? Are there any other factors that we should look at buying a resale?
The next stage is to get your permission to purchase application. And when you're going through permission to purchase application, it takes a long time. It can take from 8 to 13 months. It's very important in the contract of sale that we include a clause that in the event that the purchaser does not obtain this permission, they can sell it to a third party, or they can choose a nominee to take the deeds in their names.
And if, for example, we want to transfer title deed into our name, but the company is no longer active, what do we do in that case?
If the company is not active, and if you already done the stamping and registration, then you are preferential creditor. So this route, you will have to take a legal action to get the value of the property back.
And if the owner is not the company but the individual who has the title deed transferred into his name, and we bought the property from him and we want to transfer the title deed, but something happens to that owner, let's say we cannot find him or got he dies or anything, what
So
do you do in that case?
if you're purchasing from an individual, not a company, 5% VAT is not applicable. Of course, they shouldn't be also a professional vendor. So it's very important to make your contract of sale to secure your rights. And you have to ensure you keep a retention, for instance. Retention is maybe 3%, 4% of the purchase price. You can hold it until you get transfer of title deeds. Another
so this is
option,
some kind of guarantee that
yes,
you will
that's
get it.
correct. Another option is to get a full power of attorney from the vendor that you can sell it to another party to do in all formalities. But we advise all our clients to provide all the necessary paperwork to their lawyers so they can get the transfer of title deed in their name directly, because there is an issue that the vendor can pass away. Of course, there's ways to it. You have to set up a probate, you have to track down their family members to obtain the death certificate.
So there is a way, but it might take longer.
A longer process, yes.
And are there any risks if we do not transfer the title deed in our name? If we just leave it on the previous owner, can we do that? Or is there any law that specifies that we should transfer the title deed in some particular period of time?
No, but we advise our clients to be ready to pay their transfer charges and cut the ties with the vendor so they can sell the property whenever they want and they become the fully owner of the property. So we do not advise our clients to keep to be a contractual owner for a long time.
Bilga, you also mentioned this permission to purchase. During the process of obtaining this permission, what should we be aware of?
Permission to purchase is application made to the Council of Ministers. We ask our clients to obtain a police certificate from their country of origin, and for this permission to be refused, there is usually two reasons. One is that the property is close to our army base or naval base, or if the purchaser has a previous criminal conviction. So these are the main two reasons that your permission can be refused. But again, there is ways where you can hold on trust, or you can set a company to keep the property in your name.
And if the current owner of the property has a title deed into his name, does it mean that most probably I will get it in my name, or there might be some problems with that?
If the former owner was a non-citizen as well, then it is very likely that you will obtain it as well.
Okay, Bilgay, thank you so much. I think you had all the questions covered in detail.
Thank you very much. Very nice to meet you.
Все обсудили. Светлана, спасибо вам большое. Большое вам спасибо. Очень информативная была встреча. Bilgay, thank you very much. Thank you very much.
Very nice to meet you.
God save the Queen. Я просто должен откланяться. Спасибо вам еще раз большое. Ребята, мы отправляемся дальше на поиски приключений. Вот сегодня побывали в офисе Дом.Инфо, пообщались с юристом Bilgay Akil. Я немножко опоздал, но я думаю, было информативно. Для тех, у кого будут еще какие-то вопросы, задавайте, ставьте лайки, пишите комментарии, а мне нужно бежать дальше. Bye-bye!